Hi there. This video is produced by Francis Tom Temprosa. He is an adjunct professor of law at the Ateneo de Manila Law School. The objective of this video is to supplement the readings in his class on legal techniques and logic. So, let's first do an introduction by way of a recap. The most important thing for me is for you to think like a lawyer. At the beginning of this course, I taught you the importance of thinking like a lawyer. According to Anne-Marie Slaughter in her speech on thinking like a lawyer means, in the first instance, thinking with care and precision, reading and speaking with attention to nuance and detail. It means paying attention to language, but also understanding that words can have myriad meanings and can often be manipulated. It thus also means paying attention to context and contingency. In part, Anne-Marie also says that thinking like a lawyer also means that you can make arguments on any side of any question. Many of you resist that teaching, thinking that we are stripping you of your personal principles and convictions, transforming you into a hired gun. On the contrary, learning how to make arguments on different sides of a question is learning that there are arguments on both sides, and learning how to hear them. Also, thinking like a lawyer also means exercising judgment, distinguishing among those arguments, sifting good from bad. Learning to think like a lawyer means learning to reject some arguments and to embrace others, and to know and be able to articulate why. Lastly, thinking like a lawyer means combining realism with idealism. It means believing in the possibility and the desirability of both order and justice, and in the capacity of the law to help us achieve them. But it also means knowing the full range of human conduct, and understanding that grand principles will remain paper principles unless they are implemented with an eye to human incentives. Then we went on to discuss what basic legal reasoning is. The first step in legal reasoning is to identify the law that is potentially applicable to a particular situation. Within it, you need to identify the issues, questions, or issues that may come before a court are of three types: issues of fact, issues of law, and issues requiring the application of law to fact. Issues of fact all pose essentially the same basic question: what is the situation to which the law must be applied? In other words, what events have occurred to create the dispute? Issues of law also pose essentially one basic question: what are the rules of law governing this dispute? Issues requiring the application of law to fact similarly pose one general question: what rights or duties exist between the parties under the governing law in this situation? These issues are sometimes called mixed questions of law and fact. We then turned to the second step of legal reasoning, which is to analyze the plausibly applicable statutes and cases to identify both the rules of law and the underlying policies contained in them. We discussed some techniques for analyzing statutes and cases. Case law requires different techniques of analysis compared to enacted law or statutory law. Now, the third step in legal reasoning is to synthesize the rules of law into a single coherent framework that can be applied to the facts. You must determine the relationship that each rule bears to others. Also, at times, you should construct a second, somewhat different, type of synthesis. Our readings tell us that this is the synthesis of a single rule from a number of holdings to govern a situation not within the factual predicate of any prior rule or holding. Thus, in this second type of synthesis, the result is not a framework of rules but a single rule. This rule, of course, once constructed, is integrated into the larger framework of rules. Generally speaking, how do you synthesize the rules of law? According to our readings, the key organizing principle in legal reasoning is to move from the general to the specific. You usually begin with general rules of law, which direct the search to more specific rules, and then can be applied to specific facts to produce a conclusion. Rules can define an element of a more general rule. Rules could apply a more general rule. Rules could limit a more general rule. A rule may be cumulative to another, in that it may describe a different right or duty than another rule, or it may describe a different set of facts that may give rise to the same right or duty. What if possibly applicable rules contradict each other? A rule can surely contradict another. For example, one rule could say that a particular right or duty exists under a specific set of circumstances. Another rule could say that no such right or duty exists under the same set of circumstances. Traditional legal thinking says that the contradiction should be resolved. But how do we resolve them when they contradict each other? According to our readings, here are some ways to do it as lawyers do. First, treat one rule as simply superseding the other. Constitutional rules supersede ordinary rules, right? If the rules come from the same source, then the rule that was developed later in time often supersedes the earlier rule. A second way is to treat one rule as a limitation on, or an exception to, another rule. One rule becomes an exception to the general rule. You often hear rules having exceptions. A third way is to say that each rule respectively applies only to a specific set of circumstances. They are mutually exclusive in that sense, not a limit to another and not superseding another. Alright, there is another way to synthesize rules. This is moving from specific to general. This usually arises when you want to establish the existence of a rule that has not been previously explicitly recognized or articulated. There are times when the situation at hand is unprecedented or courts have declined or have never been confronted by the situation. The statutes are quiet about it. So what do? You do it through induction. You could say, for example, that the court has ruled in a certain manner in previous cases, and so we can induce a certain rule of law from that trend. This is not a mechanical process because the law could be indeterminate and policy arguments help. When you synthesize a new rule, you either support the new rule or oppose it. According to our reading, the fourth step in legal reasoning is to research the facts to which the law must be applied. I want you to know that limited factual inquiry is, in fact, the first step of the legal reasoning process because as a lawyer, you determine what preliminary facts are important in order to find rules. There is always an interplay between factual research and other steps of legal reasoning. A fact is that which can be proved to a jury or to a judge or to anyone sitting as the finder of fact. Can the facts eventually found be different from the evidence or factual version of a lawyer? Yes. First, because some evidence may be inadmissible or irrelevant. It could be excluded for other reasons like unreliability, hearsay, an example of a prior bad act or privileged. Second, even assuming that all available evidence is admitted at trial, the evidence could be unreliable, incomplete, uncertain, or contradictory. When you are at trial, you try to produce the past and it will always be incomplete. That is why we require some degree of inference and judgment, about which reasonable people can differ. Burdens of proof and presumptions are important. Third, fact finders could be influenced by cognitive biases. According to our readings, the last step in legal reasoning process is to apply the law to the facts to determine the rights and duties of those involved in the situation. In this, policy is involved because the law actually consists of rules and underlying policies. A lawyer also reasons using policies. When you apply rules, you seek consistency with past decisions, and if I may add, also with current laws. When you reason through policies, you look to consequences. In this part, we will deal with applying rules. We will go back to applying policies later. When we apply rules, we do it either through deduction or analogy. In the basic model of deduction, using syllogisms is the most dominant style of legal reasoning. A syllogism consists of a major premise, a minor premise, and a conclusion. As we know from the readings, the major premise posits a statement that is true of a class of objects. The minor premise characterizes a particular object as belonging to the class, and the conclusion asserts that the statement is therefore true of the particular object. The major premise is the rule of law. The minor premise characterizes a particular situation either satisfying or not satisfying the elements of a factual predicate. The conclusion states whether the right or duty in the rule exists or not under the factual situation. For example, The legal rule states that a person is liable for murder for taking away another's life. X took away Y's life, a person. Therefore, X is liable for murder. Syllogistic reasoning presumes that we can apply the law to facts in a mechanical manner by reference only to the language of the rule. This is called textualism or formalism. But we cannot do that all the time, and legal reasoning can often be indeterminate. The lawyer cannot reach a firm conclusion by merely applying the plain language of rules to facts. For example, a rule can use standards like reasonableness or good faith. That is not easy to determine. You can address indeterminacy through specificity. Find a more specific rule that could more squarely fall with the situation. You can also address indeterminacy with the aid of the rules of statutory construction because we deal with rules here. You can also use policy judgments. You can do these to decide cases or to advocate for causes. You can use analogies to supplement deduction. Examine precedents for analogies to the current situation. You can also apply rules to facts through reasoning by analogy. According to the readings, analogy is a form of logic through which one reasons that because two items are alike in at least one respect, they are alike in at least one other respect. It comparing and contrasting things, but the things that you compare here are judicial decisions with the purpose of determining whether, in the second case, the current situation, a person has some legal right or duty that also existed in the first case. You can either conclude that precedent should be followed or that the precedent should be distinguished. There are 3 steps. 1. Identify a rule or holding announced in a prior case. It is like the major premise in a syllogism. 2. Determine whether the facts of the current situation are like those of the prior case. This is like the minor premise of a syllogism. 3. Characterize the facts as like or unlike those of the precedent, leading to a conclusion that the current situation should or should not have the same legal consequence as the facts in the precedent. For example, in A versus B, the court ruled that murder is committed when a person kills another with evident premeditation. With the ruling in mind, look at the facts and circumstances in the present possible case of murder and compare it to those in the previous case, then conclude whether murder has been committed. Now, this is where it gets really interesting because no 2 cases are identical in every conceivable respect. You cannot also look into every conceivable case in the world decided on the matter. The facts in cases, like apples, do not have to be completely identical. You do not also absolutely have to survey all the cases in the world to come up with a good argument. The facts of the cases considered just have to be identical on the dispositive facts. As a lawyer, you decide using the facts, what the dispositive facts are or are not in the precedent compared to the current case. You can also state facts of the precedent in a general or in a narrow way as an advocate, and as a judge, rule which facts are dispositive or not. Policy arguments will also help you in your argumentation. Our reading says that the lawyer generally must decide, based on judgments of ends and means and values, whether characterizing the facts of the current case as like those of the prior case would yield more policy benefit than characterizing them as unlike those of the prior case. If so, then the prior case will be followed. If not, then the prior case will be distinguished. Remember the phrase, falling squarely with the facts of the present case? That's it when you want the precedent to be followed. Otherwise, if the facts are not all fours or not inside the proverbial square, then that's when you want the precedent to be distinguished from the present case. You have to keep in mind this: logic alone does not determine how policies play a role. The process is likened to drawing a line between applicable and inapplicable situations or to balancing the dangers against the burden of a warning in each particular situation. My tip is to ask yourself, will applying the ruling or doctrine further or block a policy under the law or case law? Think also of the intent or spirit of the law. So, that's it. In this video, I talked about the importance of thinking like a lawyer and what it really means. I also described legal reasoning. The steps are identifying the applicable law, analyzing the law, synthesizing the law, researching the facts, and applying the law. It is a very dynamic and interconnected process. In the next video, we will look at reasoning with policies, one of the greatest techniques of a good lawyer. See you then.